Join us on the program right now, though. Very pleased to have with us the research director at the Independence Institute, Mr. Dave Kopel. Dave, good evening to you, sir.
Good evening to you.
I want to thank you very much for coming on the program. There's a lot of stuff that I want to talk about tonight, but let's start with your piece in the Washington Times, Debunking the Stand Your Ground myth. We have seen a lot of myth-making, I think, over the past couple of weeks, and your piece in the Times, I really think, clarifies this. Is this based on your post from the at the Volokh conspiracy? Is this fleshed out?
What I wrote on exactly. What I wrote on Volokh on Monday was the Volokh obviously is for primarily legal audience, so it went into a lot of details about the precise language of Florida statutes and laws in other states, and famous legal commentators like Blackstone and things like that, Supreme Court cases. And then for the piece that was published yesterday online and this morning in print in the Washington Times, I took that and wrote it up as something for normal people to read.
Okay, and so you say whatever happened on the night that George Zimmerman shot Trayvon Martin, we know one thing for sure. The gun prohibition lobbies and their compliant media friends have been deceiving the public about Florida's laws. Among the many deceits is the claim that Florida's Stand Your Ground law affects the legality of whatever Mr. Zimmerman did. Okay, so why is that a myth, Dave?
Well, Stand Your Ground is a law that says when you're in a public place and you are attacked by a violent felon, you can immediately use force, including deadly force, depending on the type of attack, if you need to, for protection. And you don't have to retreat first before you can use force. Nobody's going to. The point of the law is some prosecutor can't make you spend $100,000 defending your life the second time against an unfair criminal prosecution by saying, oh, he could have run away, when that's too much a burden to put on people, because even the prior law said you only have to flee if you can do so in complete safety. And who's to judge the complete safety at a particular situation? As Supreme Court Justice Oliver Holmes wrote in a famous Stand Your Ground case in 1921, detached reflection is not required at the point of an uplifted knife. So anyway, Stand Your Ground is about when, if ever, there is a duty to retreat before using force in self-defense. Zimmerman's lawyer says he will not rely on this law, which makes sense because under Zimmerman's version of the facts, Martin attacked him, knocked him to the ground, was slamming his head in the concrete and trying to grab his gun. And, of course, under those situations, there's no opportunity to retreat. You don't retreat when somebody's on top of you, banging your head into the pavement. Now, so that's the Zimmerman version of events. Mm-hmm. And he says, we're not going to use Stand Your Ground. So it's plainly not relevant on that. Then there's the other version of events, which is the one put out by the PR firm working for the Martin family. And in that view, Zimmerman just attacked Martin. Well, if Zimmerman was the attacker, then, of course, he was the violent, criminal, felonious aggressor. And he wouldn't have any self-defense rights at all. So the details about exactly when you can use self-defense have nothing to do with Zimmerman's actions if Zimmerman was indeed the criminal attacker. We don't know which story is right. That's why there's a grand jury that will investigate this rather than having trial by infotainment on CNN and NBC.
Mm-hmm.
But whatever we know, no matter what, with the two versions of the story, under neither of them does the situation have any possible relation to the Stand Your Ground law.
And, it's interesting, Dave, that you point out the quote from Justice Holmes, where you said 1921.
Exactly. So, and Justice Holmes, is well known as one of the most important Supreme Court justices, but shockingly, he wasn't a member of the National Rifle Association. And, this idea didn't originate with the NRA. It is something that you can find in Supreme Court opinions going back to 1895 and deeper roots than that in American state law.
Absolutely. And I'm guessing, Dave, if you wanted to even go back even further, you would find similar laws in place in England or Western Europe, dating back even further.
Well, that's right, and so you can go back to Blackstone, who wrote the famous treatise on the English common law. He published in 4 volumes between 1765 and 1769.
Mm-hmm.
Under the Blackstone view, and Blackstone is sort of known as like the definition of middle of the road conventional wisdom of his time. Under Blackstone's view, you had an actual duty not to retreat, but to use force to prevent the commission of a violent felony, such as a robbery or an arson or a rape or something like that. He did say there was a duty to retreat when what was going on was a sudden quarrel or a fray. So, 2 guys get into a fight in a bar. Under the Blackstone common law, there would be a duty to retreat if you could in complete safety before using force in self-defense. But then there's plenty of other situations like we just talked about where the Blackstone English common law would say there's an obligation not to retreat, and you must stand your ground and use force to prevent the commission of these violent felonies.
All right. Well, listen, Dave, I appreciate you coming on the program, sir. We only have about a minute left, but I've got to ask you, we heard once again Felipe Calderon say that we need a ban on semi-automatic rifles, presumably semi-automatic firearms in general here in the United States in order for Mexico to combat drug cartel violence. Same song, different verse from the president.
Yes, but as a matter of compromise, I would be willing to stop using federal tax dollars to have semi-automatic firearms delivered to Mexican drug cartels. I think we ought to be willing to make that step, and it's somewhat disappointing that President Obama hasn't taken anything to effectuate that form of common sense gun control.
We didn't hear Calderon bring up Fast and Furious yesterday. Apparently, he's decided he's just going to let it drop.
Man, what a polite fellow.
How about that?
Boy, if somebody else was at the head of an organization that had shipped 2,000 guns used for 300 murders, according to the Mexican Attorney General, into my country, and I ran into the guy who was ultimately responsible for it, I might have a few words about it. But, I guess President Calderon is exceedingly polite with President Obama. And it always just says he deeply respects the Second Amendment.
Yeah.
And if that were true, maybe he could actually obey Mexico's constitutional right to arms, which says people do in Mexico, they do have a written constitutional right to arms.
That's what it says. Absolutely.
For guns in their home for self-defense.
Dave, thank you again, sir. Appreciate you coming on the program.